All right. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon, gentlemen. How are you?
Good afternoon, Your Honor.
Oh, Your Honor.
So I wanted to have you in again because I have a whole lot of questions. And I'm going to make sure that I get them out. My first one, though, is there still a contempt proceeding scheduled for the 28th?
Yes, Your Honor.
Okay. Mr. Gould, this is your petition. Why don't you start? And as you probably experienced the last time, I'm going to undoubtedly have a few questions.
Thank you for, and may it please the court. The land court judge has sua sponte ordered us to respond to a contempt proceeding for 9 city council members, 2 who are no longer serving with the board, a few that are elderly on its own initiative. There's a case, District Attorney versus Flatley, that stands for it's appropriate for the appeals court to interject before an adjudication of contempt. The site is 419 Mass 507.
Is that in your briefs?
No, it's not.
Yeah, I didn't remember seeing that. In fact, I didn't remember seeing much law of anything in either one of your briefs. Okay, I will take a look at, what do you think that case stands for? What proposition? Simply that I can interfere with a contempt proceeding?
Yes, that it is more appropriate to interject before there's a contempt adjudication.
Okay, I'll take a look at that. I don't know that matters much to me. Let's start with my questions. First of all, you make something in your pleadings of the fact that each of your clients has received a subpoena for the contempt proceeding. Have you checked with the court to find out whether your clients actually have to appear?
So the court has clarified that they're only requesting attorneys to appear.
Only attorneys. Don't you think that was an important thing to tell me, Mr. Gould?
I didn't know that. When I filed the brief, I found out afterwards.
Right, but you probably knew it before I decided to have a hearing.
I apologize for not filing that.
Well, when you write a brief that says the court has required under penalty of arrest that my clients appear, and then it turns out that's not true because you didn't check, you need to tell me. Because honestly, that was one of the things that impelled me to have this hearing.
And that is a possible outcome, Your Honor. It's a serious proceeding. I'm scrambling to protect my clients.
I understand you're scrambling to protect your clients, and I have lots of questions for the other side as well. But one of the things that I will tell both of you in watching this play out is that I'm not too comfortable with any of the players really paying attention to what the rules are. And that goes in many, many directions. This thing did not need to play out the way it has played out. Actions by the city of Taunton, which could have not been taken, were taken. Actions which could have been taken by Bask were not taken. And so this is the 3rd time now I'm seeing this case, and you have a land court judge who's very upset. And the question is, what do we do with it? I'm not surprised to learn that it was not their intent to have your clients show up in person. What is your understanding of the scope of the hearing that is going to take place on Thursday?
Counsel for Bask has asked that they be awarded a license and that the other applicants be stripped of their license.
Is it your understanding the court will take up that request on Thursday?
I can't speak definitively what's in the judge's mind. I know it was
Well,
his.
I mean, one thing that could happen is he's just scheduling a further trial. Is it a scheduling hearing, or is it your understanding that it's a full hearing on the merits?
Well, I don't believe it can go forward because I think that there's due process concerns. All the boxes were checked on the notice. So it was scheduled for the purpose of saying whether an answer is required, scheduling a hearing, holding a hearing. That's not sufficient to tell us what's happening.
Okay. Have you sought clarification?
I have not, Your Honor. I frankly, we don't know how to approach, and we have. I understand that perception may be that we haven't acted appropriately. I can, tell Your Honor that we have acted in good faith, and we believe that the court should hear. I mean,
well, I'm hearing you because I understand many of the things that have happened. Look, guys, I was a civil practitioner. Okay. I think I understand what's going on. Maybe I don't. That's part of the reason for having the hearing. But I think I understand what's going on. Have you issued the special permit to Bask?
Yes, Your Honor.
You did. When did you do that?
Let me clarify. So the council approved it on January 12th, and I sent counsel for Bask a copy of the unsigned version. My understanding is 7 or 8 counselors have signed it so far. So the final permit signed by all the counselors hasn't actually physically gone out yet.
Okay, but you've decided to issue the permit, and Bask is aware that you've decided to issue the permit, and they've been aware for 2 weeks?
Yes. Or maybe I sent it to Attorney Burke within the last week.
I'm interested in when you sent it to him, because in his memorandum of law, which I received on Monday, he says you still haven't issued the permit.
I mean, I can check my email. My best recollection would be about 3 or 4 days ago.
Okay. This was filed on January 22nd. Quote, the city council has not complied with the land court's judgment that it award Bask a special permit. I'll be asking Mr. Burke about that. But you advised him on what date that the permit was going to be issued?
Here is an email from myself to Attorney Burke. It's dated January 21st at 2:05 p.m.
Thank you. Why did it take you so long to issue the special permit? You were ordered to issue the special permit on December 23rd.
So the clerk of the court was on vacation during the Christmas holiday when all this was happening. We did request a stay. When that was denied, we issued the permit, I believe, the following meeting.
You did request a stay from both the land court and from me. I understand. So that would be a basis not to do it until you found out what the answer to the stay was. And your view, your memory is that you issued the permit when do you usually meet? When does the city council meet? On Tuesdays?
Tuesday evenings, Your Honor.
So the 12th.
Correct.
Is the day that they agreed to do the permit. And was that recorded in public so that there was a public notice that the permit would issue?
Yes, that was stated in the meeting. And that will be in the meeting minutes.
And the meetings are public, they're streamed?
Yes, and recorded. So any member of the public can go back and view the meeting.
Why did the board council decide to go forward on December 28th and issue the permits that it issued?
So they, in good faith, believed that they could issue the licenses and that they were.
I'm sorry, I
doing
keep
the right
calling them
thing.
permits. I mean licenses. That's my mistake.
I know. And they did intend to preserve the status quo and held a license so as to be in their
They
view.
issued the license to the party that's within a quarter of a mile, and which was the principal issue that was litigated before the land court. You cannot tell me, you can't say to me, oh, this was done without, this was done preserving a permit, when it was very clear to everyone, once the judge issued his order, which he had issued by December 28th, that the concern was that there was a competitor who was literally across the street. Was there a discussion of that on December 28th? I'm talking about a question about a public communications. I don't want to know what you talked about with your clients.
I understand it was in the minds of the counselors that they needed to give Bask an opportunity to be heard for a license, and they do in good faith intend to do that by holding one permit back. It was not brought up at the meeting, to the best of my knowledge, that let's give it to this company and not to this company. They just considered the companies. And it is important to note that there's no requirement for public hearing or participation of applicants in these meetings. And then that's where I believe there's some miscommunication in the land court's order. To the extent that there was a hearing or public participation required by the order, that's not required by the licensing regulatory scheme. And then that's the good faith.
Look, this may all be correct, but you had a land court order, okay? And that order said three things, right?
Yes, issue the special permit, which we did. And what were the other two? And
Shall be issued in sufficient time for the plaintiff to apply for a license pursuant to the ordinances. Two, participate, and second, to participate as an applicant in any hearing held by the municipal council with respect to the issuance of licenses. And third, I'm putting in the second and third. There are three components to it. Third, that the municipal council shall consider such application by the plaintiff at any such hearing along with the other duly filed applications. Do you agree with me that your client is at risk here? If this order is valid, your client is at risk?
I understand that. I mean, they did have an opportunity to file the application. We specifically asked them to do that back in November.
They didn't have the permit yet. You guys hadn't issued it.
Your Honor, the issue of jurisdiction hasn't been resolved, and based on some counsel in your order.
I mean, yeah, you're right. The issue of jurisdiction hasn't been resolved. You spent a considerable amount of time with me and you have my order on that subject. But the law generally says you need to comply with a court order, whether you think it's invalid or not, right? If you looked at the contempt law, I didn't see either one of you briefing it. Now, there may be an exception, Mr. Gould, when the court doesn't have jurisdiction to issue the order. But the general rule is the fact that you don't think an order is valid doesn't relieve you from having to comply with it. Instead, you're supposed to take an appeal and get it overturned, which I understand you sought to stay, but you didn't get it. And your client is at risk as a result. What is it that you want me to do?
I would like Your Honor to state that the just to clarify that the jurisdiction, we frankly don't know if it's okay to give the last license out. The land court is telling us we need to have hearings with public participation. We can't even appeal that to the Superior Court. If the land court doesn't have jurisdiction to rule on it, we can't ask for clarification because they're not the appropriate court to say that. So we have to ask the appeals court.
You want me to clarify that the order is without jurisdiction?
Yes, Your Honor, and quash the contempt proceedings.
Quash the contempt proceedings. You want me to say to a judge of a trial court, you can't enforce your order.
Insofar as it takes the jurisdiction of the Superior Court without legislative authorization.
Well, certain parts of this order are not without jurisdiction, are they? He had the jurisdiction to order you to issue the special permit.
Correct. So
and if he finds that you did not act appropriately with respect to the issuance of the special permit, doesn't he have the power to issue a contempt?
The court does have contempt power to enforce their orders, which we did follow to the best of our ability.
What's the scope of the remedies that are available to him?
It's remedial, Your Honor, to fix the issue that was violated. It's here. I mean, what would he do? The only way to fix it is to order us to issue a license or to take a license away from someone. Which that's the.
Do you think that's within his authority?
No, and that's why we're asking the court to issue its to vacate the proceedings, because there's no order that can come out of these proceedings that will.
Well, unless the scope of his remedial powers in contempt may exceed his jurisdictional powers. If he issued something that he had the power to issue, I could use a little help on the law, guys. I don't see any case law on the scope of his remedial powers. None. Okay, I've looked a little bit.
I mean, there's two types of contempt. There's civil contempt, which enforces compliance, and there's punitive contempt, which either incarcerates or fines.
I'm familiar with the law. I'm familiar with the law, but I don't know the answer to the question I asked. Because in a general civil contempt, you talk about the defendant having the keys in his pocket, right? That it's remedial in the sense that it allows the defendant to comply and then the remedy ceases. But what do you do when the violation is complete? Right? Well, I mean, this isn't a situation where the remedies can simply stop. You order him do X, and if you do X, then everything's fine. Unless do X means, as you just said, and as your brother appears to be asking, rescind the licenses that you granted. Okay. Mr. Burke, I've been mean to Mr. Gould. I intend to be equally mean. Isn't the order beyond the court's jurisdiction, sir? Based on what I said and based on the communications that we had, there are at least two parts to this order that seem to me beyond the court's jurisdiction. And you don't address that. You don't address that subject in your opposition.
I thought I did, Your Honor. I think as Judge Speacher said, and as I addressed in the brief, that it is in compliance. He has the authority to order a special permit. He has the authority to order a special permit in a timely manner, which is what he did. As Judge Speacher says in his denial of the motion to stay, he felt that he was complying with the Your Honor's own interlocutory order, and that he was not enjoining the city council from holding hearings. He was not ordering that they issue licenses or anything of that nature. He was simply ordering that they issue a special permit in a timely manner so that Bask could participate in the license process. And that we submit, and as we argued in our brief, would be within his power because it's all related to the timing of the issuance of the special permit, which he has some equitable powers over under Chapter 48, Section 17.
Well, look, again, it's interesting because I think there are three components to this order. The first says the special permit shall be issued in sufficient time for the plaintiff to apply. Don't know what sufficient time means, but let's assume that he certainly has the power to order them to issue a special permit. And I think he has the power to order them to issue a special permit expeditiously, right? When he ties it to the license proceedings, it starts to bleed over the line, in my view. And then he says, and so order the special permit in sufficient time for the plaintiff to apply and to participate as an applicant in any hearing. Now, if that's simply an order that says issue the special permit expeditiously, I'm okay with it. But if what he's doing is he's also ordering the city council with respect to how it has to schedule its hearing, order the city council is hereby ordered to issue the special permit in sufficient time to participate in an applicant in any hearing, then arguably it could be violated because they scheduled their hearing in a way where the person does, where you didn't have time to participate. And the scheduling of the hearing on the licensing, I think, is outside his power. Do you have an argument for how it's inside his powers to order the city council as to how they schedule their licensing hearings?
I think, Your Honor, under Chapter 48, Section 17, the equitable power that goes with the form of the relief ordered carries over here. He's not enjoining them indefinitely from holding hearings or ordering them what to do in license hearings. He's simply ordering them to issue expeditiously, as Your Honor said, a license, a special permit, such that it will have meaning. And
Yeah. But what does that mean? It will have meat.
Well, we filed our license application. The decision of the land court was on December 23rd. My clients filed their license application on December 30th, a week later. So we're talking about a very minimal difference in time here.
But you're trying to affect the licensing process.
Well, I think the order, the court,
And
the land.
And we had this conversation when you guys first came in. And I thought at that time we talked about the fact that there might be some kind of remedy someplace else, which you've never filed a lawsuit in the Superior Court, have you, sir?
No, Your Honor, it seems
Why not?
pointless until there is because a writ of certiorari is dependent on a ruling on a license, which typically a denial of a license. We can't apply for a license until we get a special permit. We can't even be considered for a license.
You mean you couldn't get a writ of certiorari to order them to allow you to participate in the hearings?
I think the writ of certiorari law is dependent on decisions of boards that are beyond appeal. And so we clearly can't do anything in Taunton until we get a special permit, which I would submit, Your Honor, still don't have. And so I think that's why Judge Speacher, he's not making any order with regard to.
Slow down on one thing. You say you still don't have it. You know that it's coming.
Well, I asked Attorney Gould if when it could be picked up, if there was a special permit that my client could pick up, and was on the 21st, as he said, last Thursday. He emailed me that there was a form, but what I got was an unsigned form and the note that it was still in the process of being signed. So there's still no, as far as I know, even as we speak, Your Honor, I haven't talked to Attorney Gould today, but I haven't
Was there a
heard that.
meeting, Mr. Gould, was there a meeting of the city council on the 19th?
Every Tuesday, Your Honor. So
So why don't we have a signed special permit by then?
they don't meet in person, Your Honor. They're coming in individually to sign it. I mean, I know, I reached out to the clerk's office yesterday twice, and
I had missed the point. I'd missed that point. Of course, everything's virtual.
I know a majority of them have signed it. They're probably just waiting on one or two that don't get out of their houses very often because they're.
Well, I mean, I have to say that when Mr. Burke says we still don't have a special permit, I immediately think, boy, that sounds contemptuous. And Mr. Burke, the way you present it, you're leaving out the fact that it's hard for him to get the signatures.
Well, I mean, Your Honor, it's, Attorney Gould says it's going to be dated January 12, whenever they eventually all sign it. That's still long after they, 12 days after they violated the land court order, but I still don't have anything I can
They
pick
had a
up or
motion,
record.
they had a motion pending for stay. They surely they didn't have to issue it before the motion for stay was decided. I mean, this happened over Christmas time. I would say the concern that you're raising, which I think I've already talked to Mr. Gould about, which I find valid, is why did they go forward on the 28th? Why did they choose to do that?
No.
Under the circumstances? And we haven't talked about the third aspect of this order, Attorney Burke, which is that the municipal council shall consider such application by the plaintiff. That's beyond the court's jurisdiction, right?
I think that's within the general equitable powers that the land court
Order
has.
them as to what they're to do as an executive body in a licensing proceeding?
Well, it's all related, Your Honor, to the issuance of the special permit. The land court judge does not order that they issue Bask a license. He doesn't order that they not issue it to anyone else. He simply is saying, issue the special permit in a sufficiently timely manner that it has
what he
meaning.
says. Why do you think, make your best argument for how he has any power to tell the city council what to do with respect to the licensing proceeding? He has a special permit proceeding in front of him. The special permit surely is something that they need, that you need in order to get a license. And you say, well, they're related. They're only related in that fashion. What's your best argument for how he has any power to order them as to what to do in a licensing proceeding?
I think the best argument that I have, Your Honor, is in Chapter 48, Section 17, that the land court has such authority to make such other decree as justice and equity may require. And as Judge Speacher has set forth both in his original decision and judgment and in his denial of the motion to stay, that's exactly what he was attempting to do.
Do you have any cases that suggest that where the land court has jurisdiction, it also has jurisdiction to engage in ordering a public body to do something that is not before him? Are there any cases, I can't think of the hypothetical even, any cases where because he has a special permit process in front of him, that gives the judge the authority to speak to an entirely different proceeding, not before him?
Your Honor, there are very few cases.
Maybe I'm putting a rabbit in the hat by saying entirely different, but speak to a different proceeding.
There's very few cases that discuss that wording. So I think you're left with interpreting what does it mean for a judge to try to do something that he thinks is equitable. And I think what Judge Speacher tried to do here was stay as far away as he could, limiting it to the special permit in the wording that he chose to use. But there's obviously some linkage there because the special permit is leading to the eventual license. But what he's attempting to do is make the timing of the issuance of the special permit meaningful, because that's the practical reality that we're at.
Do you even have a right to have a meaningful, let's suppose that you never got your trial in August. You know, the courts were backed up, or it's COVID time and you don't have the good fortune to have a judge who's willing to do a virtual trial. Would any of your clients' rights have been violated if they'd issued these permits on December 28th? Your client hadn't even had a trial yet on the special permit?
I think that's a different scenario, Your Honor. Here, the scenario is that we did have a trial. The court made a finding.
Why don't you try to answer my question first?
I think
because there's this underlying assumption in the way you're presenting the case and in the way the court presented his position in denying the motion for stay, which is that your client has some kind of right, because it didn't get its special permit and appealed, some kind of right to participate in any hearings that go forward in the licensing context.
I don't think that's what we're saying, Your Honor, or what the land court is saying. The land court is saying that it made a decision that a special permit was wrongly denied and it should have been issued. And in exercising its power to make such other decree as justice and equity may require, the land court has made that decree as part of its judgment. It's ordering that the special permit issue and that it issue in a timely manner such that it's meaningful and not moot.
Yeah, well, I don't know that that answers my question as to whether or not
I think
you have a right not to have it be moot. That's really what my hypothetical is.
I mean, I don't
just
have,
suppose that the land court didn't get around to it.
I don't know that I have a right, Your Honor, but I think that in this case, the land court, in its exercising its jurisdiction, its equitable power, made a remedy that the land court chose to grant. I may not have a right to that, but that the land court has the power to do that, and that's where we're at.
If the order, the parts of the order that we're talking about, which I would call parts, let's talk about 2 and 3, less 1, more 2 and 3. If those are beyond the land court's jurisdiction, the land court can't issue a contempt citation for violation of those parts of the order, can it?
I think the case law, as I understand it, Your Honor, is that in this case, as the city did, they try to get a motion for a stay. It's denied. They are now appealing the judgment. It will go up for a full hearing by a panel of justices on the appeals court. At that point, if it's reversed or modified in some manner that would affect any contempt ruling, then the contempt is vacated by that, as I understand the case law.
If the court's without jurisdiction. Because the law, as I understand it, is that that you can be in contempt of an order that's wrong. That's my understanding of the law. But you can't be in contempt of an order that is without jurisdiction. If you guys want to provide me with anything on that issue, you are welcome to do so, but I will tell you that I intend to act quickly. I may not write quickly, but I intend to act quickly. So I may not even wait to hear from you, but if you've got something on these points, get it in. In your complaint for contempt, you ask the court to enter the remedy of vacating any licenses that were granted. It's request number 4. Do you intend to pursue that remedy?
We asked for it in the complaint for contempt, Your Honor. I just put a variety of potential remedies there. will be dependent on what the land court thinks the proper remedy is. If it finds that there is
What
contempt.
does Bask think? Does Bask think it's within the land court's power to enter a remedy that orders the city council to vacate the licenses or any of the licenses that it already entered?
I'm not sure I know the legal answer to that, Your Honor. I think it goes back to what's an equitable remedy for a contempt violation. And those are the practical problems that we face, is that these licenses have been issued already and there's one remaining.
Do you have any case law that supports the notion that it would be within his power to enter that kind of an order?
I don't know of any case that is in that exact situation, Your Honor. I think I can certainly try to brief that and address that issue, by tomorrow.
Yeah, I'm not sure how long I can wait, but if you get me law on that subject, I will read it. That is of interest to me, and that goes for both counsel.
The question being, Your Honor, whether the land court has the authority as a remedy for a contempt to do something with regard to these licenses.
Exactly. And see, the problem there is the answer may depend on whether it was the original order was within his jurisdiction or not within his jurisdiction. So you might want to think about it, assuming either side of that. On December 28th, your client did not have an application on file. Is that right?
That's right, Your Honor.
Why?
Well, I had written to Attorney Gould immediately and told him that Bask intended to submit its application expeditiously. I'm not sure if that letter went on or before December 28th, but I think it was before. As soon as the land court judgment came down, ordering the issuance of a special permit, I wrote to Attorney Gould. I asked him for a brief delay. I told him that we would submit a license application expeditiously now that we anticipated that we would have a special permit. And it took a couple
days. The decision came down on the 23rd. The 28th was almost the next business day, wasn't it? When did you schedule? When did the city council schedule the hearing where they indicated that they intended to issue licenses or consider the issuance of licenses?
So I can answer that. If I may preliminarily just state that there's no requirement, as you noted in the order before, to receive a special permit before applying for a license. And in fact, they did have the obligation to pursue all administrative remedies. And so they could have applied for the license a year ago, a month ago. But that said,
but they wouldn't have got it because you guys won't give it out without a special permit.
That may have been the result. They had the obligation to exhaust administrative remedies and then appeal to a court with jurisdiction, rather than backdoor it into a special permit appeal.
Well, I understand the argument. I don't know that you've ever really laid that out quite the way you just did. What you're saying is, even though they didn't get their special permit, they should have filed their application, got a no, and then they could have sought certiorari. And then even though they didn't yet have a decision from the land court on whether they should get a special permit. And maybe in some technical world that makes some sense. Although it also makes sense to me that the first thing they do is try to get the land court to order the special permit issue before they do that. And I have to think about that a little bit. When was the hearing scheduled?
So after we received Your Honor's order, December 21st, I believe the formal notice went out the 23rd. Before we received the land court's order.
Wow. You guys, we're in a hurry. When's the last time the city council acted in 2 days in order to have a hearing in 5? Over a Christmas weekend.
The council is very disappointed that their jurisdiction was taken away from them for licenses, and they were happy to.
I'm sure they're disappointed. I'm sure they're disappointed that in the trial that they had on whether they should have issued the special permit, they were found explicitly to have been acting arbitrarily and capriciously by the judge who made a finding of fact. Have they internalized that as well?
The 5 that voted for Bask were probably happy. It required a supermajority of 2/3.
Right.
6 votes. It failed 5-4.
Your Honor, to answer your earlier question, I think that the city council was holding perhaps a hearing the night, if I remember, of December 28th. And I emailed Attorney Gould and said, we've got the decision. We're going to be filing a license application. Please give a brief continuance. And then on December 28th, my client, Bask, wrote to the city council directly, indicating that they were imminently going to be filing their application that week. And then they did, in fact, they filed the application on December 30th. So that's when they filed their application for a license.
Is the application complete at this time?
I guess that's a matter of discussion, Your Honor. With the application, you have to file security plans, for lack of a better word, which are supposed to be reviewed by the police and fire department. Bask filed those security plans, as I understand it, with their application. They subsequently met with the police and fire. So we've done everything that we can to get it filed. It's in the hands of the city at this point. I don't know whether
there's some contract. There's some sort of contract you need as well, right?
I think that the ordinance contemplates that the security plans would be reviewed by police and fire, and they may have to write a letter to the city council, the fire department, and the police department saying they've reviewed them. I don't know whether other applicants have complied with that or not, Your Honor, but we filed the security plans with our application. We tried to expedite their review. We met, my client, Bask, met with the fire chief and the police chief, and we understand they're satisfied. I don't know if they've issued the letters yet, or if that's truly, as a matter of practice, a requirement.
There's another question, though, that I had, which is there's another element here that you need in order to get a license, which is you need an agreement. I forget what it's called, host community agreement.
Yes.
You have that? We
had that, and it expired because they're only good for, I think, they give you a year, I think, to build out your building. It's commonplace that they're asked to be extended. Bask has filed an application, which I think is on the city council's agenda tonight, Your Honor, actually, to have its original host community agreement issued over a year ago extended for the reasons that it hasn't been able to build during all of these appeals. A number of other applicants for these licenses have also had their host community agreements extended. So that is pending before the city council. It's the city council, again, Your Honor, that has to extend them.
Okay. And you're representing to me that if you filed, that you don't think that a certiorari application in the Superior Court can go forward without an actual denial?
I looked at the law on certiorari, Your Honor, and first of all, it's a very limited remedy. but it's generally based on a decision of the board that you're appealing that's unlawful. And,
Well,
you know,
what
you don't,
about the denial of the special permit, which made it impossible for you to get the license? So you go in and you say, we want certiorari, ordering them to hold up the hearing while we get this process completed in the land court, because they did that arbitrarily and it's caused us to be unable to get our license.
that may be,
I don't want to do your job for you, nor am I
I-
sure that I could. But the fact that you did not seek remedies in the Superior Court matters to me as I'm looking at this process.
I think Your Honor, that's just so theoretical. I mean, the order of things is that you can't move forward. These are their rules without a special permit. So Bask tried as quickly as it could to get the review of the denial of the special permit. It's an orderly.
That's the nature of attempting to get a license. You know, the rules are whatever the rules are, and if your client can't get within those rules, you don't have any.
Yeah.
You don't have any. If there are rules that the city council has with respect to what licenses they have to issue and how they have to consider the various applicants, and I'm not aware of them. In other words, I'm not aware of the fact that they can't just say, we're just going to give it to the first 5 people who came in the door. We don't care about 6, 7, or 8, even if their applications are complete at the time we give it to number 5. I just don't know. Okay. But if there are such rules, it seems to me that based on my understanding of the law, the place for you to have done something about that is the Superior Court.
There are no rules like that, Your Honor.
Well, then you don't have rights.
I think there really is nowhere to go with a writ of certiorari without a decision from the board that you're challenging. So here, to go to Superior Court and say, Your Honor, enjoin them from issuing licenses. We haven't got our special permit yet. We haven't even applied for our license yet because we can't apply for the license until we get it, but we want you to enjoin the process as to other applicants. We don't know.
I'm not sure you're right about that latter thing you just said, that you can't even apply until you get it. I think Attorney Gould may be right that you should have filed your application and said, look, we're doing this to exhaust our remedies. I mean, we went through this the last time around, how you read the ordinance. And look, guys, I understand that this is that the rules here are not yet written in stone, to say the least, with respect to how you go about getting marijuana dispensary licensing. Okay, I understand. We took a look at it and came to the same conclusion. But I am concerned about the posture in which this is coming to me now. And I think there's issues on all sides. And I'm going to have to, decide the petition. Okay, I'll give you each a last word. If there's something I'm missing that you want to make sure I particularly focus on. If there are going to be any supplemental briefs, I want you to keep them short, please. I'm really looking for authority. Say no more than 5 pages. Okay, they've got to come in quickly. Mr. Burke, why don't you go first? And then Mr. Gould, you'll get the last word.
Your Honor, I think I've done the best that I can. I'll look for other cases dealing with jurisdiction and contempt, as Your Honor raised, and I'll see what I can find. But I think the arguments that we set forth in our brief, that this is really another bite at the apple of a motion to stay. I believe that the land court acted appropriately in its judgment by acting within Chapter 48, Section 17. There's really limited cases that interpret that section of making such other decree as justice and equity may require. And so it goes back to, well, what is justice and what is equity? And I think that's what the land court was trying to do here. It may not be a right that we're entitled to. I think Your Honor made that.
It can't be uncabined, okay? It can't just be he can make whatever decree he thinks is equitable.
But I think
right?
what Judge...
It has to be cabined to some other jurisdiction that he has.
I think that's what Justice Beecher was trying to do by focusing on the timing of the issuance of the special permit so that it could be meaningful and Bask could participate in the process. He wasn't attempting to regulate the process, only the timing of the issuance of the special permit. And that, I think, is justice and equity. Otherwise, the court is rendering an order that could be meaningless and have no real practical value. And that's what I think he was attempting to do. There may not be cases.
But as I point out, that he had no obligation to have a hearing for you in August. I mean, he would have been in the same boat if he just taken longer to get to trial.
I think that's correct, Your Honor. But here we did have a trial, we did have a judgment, we did have a ruling, and then it's up to the court to decide how to apply Chapter 48, Section 17, which is what Justice Beecher was doing. He was making a judgment and he was fashioning an order, and he was attempting to do that, knowing what Your Honor had said in regard to the interlocutory appeal, and to make it a more limited order than he had done with his earlier injunction. And I think that he did that. No, Your Honor, thank you.
Do you think that I have the authority to enter an order that affects this contempt proceeding by, for example, delaying it or stopping it? Your brother has cited a case to me, which I'm going to read, District Attorney against Flatley.
I haven't read that case, Your Honor. The cases that I read were all after a full appeal where there was a ruling on an injunction and then a related contempt proceeding would rise or fall with the ruling on that injunction. So I'm not aware, I'll look at the Flatley case. I'm not aware of a court decision that would talk about this situation where the court would stop a contempt proceeding after a denial of a motion to stay. I think it's better for...
Look, but that argument to me is not strong. That first argument in your brief where you say they already had their shot, the motion to stay was denied. Their motion to stay was a motion to stay the order that was entered on December 23rd. Now they're saying there's a new proceeding, a contempt proceeding is a new complaint, and we want you to stop that. And it seems to me that is different. Okay, so I did not find that argument persuasive, and I will not find that argument persuasive. Mr. Gould, last word.
Just that the municipal council did act in good faith. They issued the special permit as soon as the motion to stay was denied, and there is an application in that will be considered as any other applicant, and that's the remedy that was asked for in the lower court case, and that's the remedy that was awarded, and it really should end at that.
I'm sorry, I lost you there. What's the remedy that was sought in the lower court?
The special permit. That the case was about a special permit, and that has been awarded. The judge awarded it. The city awarded it. It's in the mail, so to speak, but it will be in Bask's hand. I'll follow up today, but I would assume it would arrive by the end of the week, and that should resolve the matter.
Okay. Anything else?
No, thank you, Your Honor.
That if there's an injunction, that the Superior Court would be the place, and then we wouldn't be able to fight jurisdiction, because that's where it's supposed to be. And just lastly, it's hard to imagine that the court would have jurisdiction to do in a final order what they didn't in an interlocutory order.
I understand that point, but the It's not an interlocutory order. It's an order in a different proceeding on contempt. And the question is, what's the scope of the remedial power in contempt? But if your point is, it's hard to imagine that remedial power could exist if they didn't have jurisdiction to enter the order that they're now claiming they're in contempt of, I understand that point.
Correct, Your Honor, and I'll just point out that the equity jurisdiction in 40A section 17 must be read in peri materia in harmony with the court's jurisdiction under 185 and interest in land. That's the intent of it. It was, if a case is proceeding, let's enjoin them from building an 8-foot fence instead of a 6-foot fence. Or
why do they have to be read in peri materia? Aren't they separate grants of jurisdiction?
Well, I mean, if whenever possible, statutes need to be read as a harmonious whole, and one can't.
But is oh, okay. So wait, I just want to make sure. The jurisdictional grant in 185 includes zoning cases under 40A, right?
Yes, Your Honor.
Okay. So 40A isn't its own head of jurisdiction. 185 is the head of jurisdiction.
Correct, Your Honor.
The difficulty you have, Mr. Gould, is that your client acted extraordinarily quickly over a Christmas holiday to issue 3 licenses once they'd been told that Bask needed a special permit. And those are the facts.
Okay.
Thank you both, gentlemen. I will get an order out. If you have additional things that you want to get to me, you need to get them to me, and I appreciate both of you taking the time today.
Thank you, Your Honor.
Thank you.